I'm Jon Caldara, president of the Independence Institute and your devil's advocate. With me, one of my dear friends, Dave Kopel. Congratulations on another U.S. Supreme Court victory for gun owners.
Thank you very much. It's a tremendous step for civil rights. It's what Congress and the American people intended to get done in 1866 to 68 when they enacted the 14th Amendment, and we finally made it happen.
All right, for people who don't follow, we've had two remarkable U.S. Supreme Court decisions in just a couple of years that has now made it very, very clear that you and I, American citizens, have an individual right to keep and bear arms. And what I want to do in the course of this show is talk a little bit about your work and Independence Institute's work on bringing that forward over the years. But give me the basic argument. When I would say there's an individual right, I'd always hear people saying, no, there's not an individual right. It's a collective right. There's this thing about the well-regulated militia in the Second Amendment. And so the right of the people to keep and bear arms, it's not the people as it is in the First Amendment or the Fourth Amendment. It's a different type of people. We always argued what before these decisions?
Well, you had some of the gun prohibitionist people would tell you it's a collective right, although of course they could never specify any of the content of what they meant by that collective right, because in an American legal sense it's sort of a oxymoron. It's like collective property in Maoist China, which is, sure, it belongs to everybody all at once equally, but in fact it belongs in practice only to the government. So you wonder why our framers would have gone to such an exercise in futility to create something that basically had no legal meaning, which is what the collective right version of the Second Amendment is.
In the First Amendment, it says the right of the people to assemble.
Peaceably to assemble.
To the right of, in the Fourth Amendment, we talk about the right of people to be secure, free of searches.
From unreasonable searches and seizures.
And in the Second Amendment, we have the right of the people to keep and bear arms, but we've got this rather clumsy clause in front of it that says a well-regulated militia being necessary to the security of a free state. Give me the whole.
A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And this has always been the difficult thing for the gun prohibition people, is that it's the right of the people. It's not the right of the militia. And the prohibitionists claim, well, this just means that if Congress neglects to arm the militia, then the states can arm the militia. Well, actually, there was an amendment that specifically would have done that in straightforward language, proposed by Senator Roger Sherman of Rhode Island. It was rejected.
When was that?
During the first Congress, the Congress that enacted the Bill of Rights, is written by James Madison. The phrasing is the right of the people, as you say, the people, and what the Supreme Court said in a case called Verdugo Urquidez in 1989 is the people is a term of art used in the Constitution, and it means the American people. It doesn't mean, say, the Mexican people, and it doesn't mean the state governments or something else. It means the people. So, now, the opening clause, it's unique in the U.S. Constitution, but it's a common style in state constitutions of the period. It's called a purpose clause. So, for example, if you could have a state constitution might say, economy and thrift being necessary in a young state, comma, the legislature may not raise its own pay during the session that session of the legislature. And so you have a purpose clause. You have the effective clause, the main clause, says no pay raises.
Then explain to me the purpose clause in the Second Amendment. A well-regulated militia. Let's just take those words. What is a well-regulated militia? What is a militia for those people who don't follow?
Well, a militia is distinct from a standing army. A standing army, very much feared by the framers. It was what the redcoats were, made up of the dregs of society plus the aristocratic officer corps. People who were full-time soldiers, and therefore, in the view of the framers, had no independence, were totally under the command of the government, didn't have any sort of civil existence outside of the government. And a militia, in contrast, is citizen soldiers, people who are mainly farmers or tradesmen or whatever, and then who come together to serve their country.
Not the guys running down to the Mexican border, but the original Minutemen who would leave their farm, grab their Kentucky long rifle, and go do service.
That's right. The Minutemen, in particular, were a highly trained subset of the militia, because that's what made them able to get ready and go in a minute.
Well-regulated. Give me the quick term of art, a well-regulated militia.
Well, regulation is making something function properly. So you could regulate a clock so it keeps proper time. You would regulate a double-barreled shotgun so that both barrels shoot at the same place.
Well-regulated. I, like most Americans, think, well, that means well-regulated. It has regulations from an authority, assuming the government, and therefore a well-regulated militia must be a well-regulated, that is, lots of regulations, a lot of bureaucratic control over a militia.
Well,
Was that the meaning?
Well, the point of well-regulation isn't paperwork or having lots of things in the Code of Federal Regulations. The point is proper functioning. So certainly one of the things a well-regulated militia can do is it can march in proper formations. If the officer says, okay, we've been firing straight ahead, now everybody wheel around so that we're now facing the right flank and go that way, that's what a well-regulated militia would be able to do. So a well-regulated militia is certainly not just anybody doing anything. It's being part of a structure which is led by the government and functions properly.
What if I said that this first clause, the introductory clause to the Second Amendment, was so that there can be mass mayhem, rape, torture, and gunfights in the street, or so that there can be total control of the government? That introductory clause really doesn't have a whole lot of meaning. Isn't it the real clause, the right of the people to keep and bear arms shall not be infringed? Isn't that the meat of the Second Amendment?
Well, in a legal sense, that's mostly true, because just like with this, the hypothetical I gave you about the clause saying the legislature can't raise its own pay, if we are no longer in a young state, the state's been around for 200 years, and it's actually so wealthy that they don't have nowhere to spend all the state revenue, even if you disagree with the purpose clause, then the main clause, however, still has legal effect. The main clause is the legislature can't raise its own pay, and if you think the purpose clause is obsolete or irrelevant, doesn't matter. The main clause is in effect. And likewise, the main clause of the Second Amendment is the right of the people to keep and bear arms.
All right, let's go forward 200 years. So we have this bit of the Constitution and the Bill of Rights that everyone seems to be arguing about. And you have been intimately involved in the legal discussions of these two important Supreme Court decisions. One, the Heller case that came out of D.C., which said the federal government, yes, it's true, the federal government can't infringe your right to keep and bear arms, and overturned a, 35-year-old
Not
gun
overturned,
ban.
it interpreted it, overturned the 1976 D.C. handgun ban.
All right,
That's
so
right.
now, and that decision in Heller, and your work was key. In fact, you sat on the lawyer's bench, which must have been an incredible high for any lawyer to be there during oral arguments of a Supreme Court. At basic, what was Heller versus D.C.? What was at the core of that? District
of Columbia versus Heller decides that the Second Amendment indeed is a normal individual right. And all 9 justices, by the way, agreed on that point. The majority thought it was a regular right, just like the First Amendment. Others said, no, it's an individual right, but only for militiamen. But this whole collective rights, states' rights thing, which the gun ban people had been
because I remember up to this
40
point,
years was rejected.
Yeah, up to this point, people would say it's not an individual right. After Heller, it was clear on a federal level, it was in fact ruled by the Supreme Court an individual right to keep and bear arms.
All 9 justices agree that it's an individual right. They disagreed on the scope of it. The majority said it's a regular right, just like your First or Fourth Amendment rights, that applies to all the people. And at the core of the right is the right to have a firearm in your home that's usable for self-defense.
And the D.C. ban was so incredibly archaic, so malicious that you couldn't even own a gun and keep it in your home unless it was completely disassembled, correct?